Where there is a wrong, there is always a remedy. If there is a breach of contract, how do you go about it? What do you need to do? What rights or what remedies are available to you? That's what we want to discuss today. Welcome to LEducation, our weekly legal podcast, where we break down legal issues, legal topics, legal concepts to your understanding without having to go to the law school. Now, before we go into today's discussion, have you registered for our free business webinar? If you have not, please do it. The link will be in the caption below. Where there is a breach of contract, what are you expected to do, or what are the options available to you? Well, there are different kinds of remedies that you may be asking for, but usually we advise that you take certain preliminary steps to be able to see whether the matter can be resolved amicably. Number one thing, you tend to speak directly to whoever you enter the contract with to see whether by direct communication you can resolve the matter. All right. If that fails, it is important that you serve a demand notice, especially if it is if money is involved or whatever. Even for there is a service they need to render to you, or there is something they need to do and all of that, it is important that you serve that demand notice, demanding them either to pay you or either to perform the duty that they owe you. Now, if all of these have now failed, there are different remedies available to you. Number one, you can go to court and ask for order of specific performance. What that means is you are asking the court to compel the other person to come and perform his specific duties under the contract. All right. Mr. Hay has said he's going to bring a car for you after you make payment. Now you have made payment and he has refused to bring the car. You can ask the court to compel him to supply that car to you. Another very important thing you can do, or you can ask the court for, is for monetary damages. Ask the court that you have suffered so much loss due to the failure of the person to perform their duties and all, or whatever the psychological stress you have gone through and everything. You can go to court and ask for damages, whether special damages or general damages. Special damages, that is the particular thing they are supposed to do, which you will have to list and you will have to prove to the court. I don't want to bug you with so much English, but general damages, due to the fact that they have breached your contract, you have suffered loss, you have suffered psychological trauma and all of that, the court can award general damages to you. That one, you don't need to specifically prove general damages, but for special damages, you need to prove them. Thirdly, you can ask for rescission or restitution, that is, that you be discharged from that contract. You can ask the court to discharge you from that contract if you are still owing any obligation under the contract, but due to the breach of the contract, due to the breach of the contract by the other party, you can ask the court to discharge you from any further duty under that contract. Very importantly, there is a limitation. It is under the statute of limitation. There is a limitation to when you can bring an action for breach of contract. In Nigeria, 6 years is the time limit between the time that the breach occurred and the time which you can bring your action. What does that mean? If somebody breaches an agreement with a contract that you entered together in the year 2025, for instance, you have up till 2031 to be able to bring an action against them. If that action is not brought within that time, it will be caught up by the statute of limitation. There is a way in which we can resuscitate it, but you need to consult your lawyer for further advice on that. This is where we are going to stop for today. Please join us again next week and ensure that you subscribe, you share, and ensure that you also register for our free business webinar. Thank you.